All right, good afternoon.
Good afternoon.
Thank you all for being with us. This is our second day of hearings in San Francisco, as you know, and many of you have watched some of the earlier proceedings either here in San Francisco or on our website, and this proceeding will be archived as well. I'm Judge Dale Fisher from the Central District of California, and I'll be chairing this hearing. We'd like to ask you to give a brief opening statement if you'd like to do that. In no more than 5 minutes. We have read all of your testimony carefully, and as you've seen, if you've been here, our committee members have a lot of questions that we'd like to ask and get information from you. And come on down. We'll start off with our panel members here with questions, and then I'll ask all of the committee to join in with some questions. And with us today we have Marilyn Bednarski, our co-panel rep from the Central District of California, Victoria Bonilla Arguedo. Thank you. Panel rep, and Wendy Curtis Palin, another district representative, and Mary McNamara from here in the Northern District. And so your bookends, Anthony Solis, our co-panel rep from the Central District of California. So welcome and thank you for being here. Mr. Solis, why don't we start with you?
Thank you, Your Honor. Real briefly, Marilyn and I testified as a unit together. We're co-panel representatives from the Central District of California. We're both active members of our own panel. We laid out some of the chief problems that we see, one of which is the panel's dependence on the court for reviewing our vouchers and for payment. We think that there should be some kind of independence from that, because when the court controls all of our payments, they control our function. We think that the court, actually the presiding judge, should not have so much control over the funding we get, the services we provide. And in that regard, most of what we want to talk about today is laid out in our testimony. I did hear the previous panel and sat through Judge Carter's testimony. I couldn't disagree with it more, and I'm happy to take and talk about it in terms of questions that are focused toward the things that this committee wants to talk about.
On what point?
I'm sorry?
On what point do you disagree with him?
Almost every point. Almost every point. But I'd be happy to talk about it as specific to what the concerns of this committee are. I do think, I don't want to interrupt anyone's introduction, but for example, when you ask me what do I disagree with Judge Carter about specifically, number one, I don't think district judges have enough of there's an inherent conflict that someone that is presiding over a case that I'm asking you for services, or I want to make a particular motion, there's some inherent judgments when a judge is going to think, is this too much litigation? Is this service really necessary? Someone who's independent from that doesn't have that same calculus. At the same time, the person sitting on the other end of the table for me, not this one, but the council table, the government never has to think about, I have to submit this to this judge and he or she is going to be able to evaluate whether or not this service is appropriate. You heard the testimony of Mark Windsor, hopefully some of you did yesterday. In that case, a judge cut his voucher after determining in a written opinion that his defense of a particular defendant for whom the government was trying to take away his entire life was a scorched earth policy. I don't know any defender that would come to that same calculation. So when I understand that when you get an Article III judgeship, you think that you can make independent decisions and they're always going to be fair. But in the judicial system, there's judges above you and above that. So I don't think that that just because a judge is fair, and many judges that I appear before are fair, that doesn't mean that every decision they make in that case is going to be fair. And with regard to funding, if I'm appearing before that case, that same judge is going to rule on the motion and going to decide whether or not and how much I should be paid for that motion. There's an inherent conflict that interferes with my defense function. And that is probably one of the core disagreements that I have with Judge Carter. There
Move
are
on.
more, but
Let's move on to Ms. McNamara, and I'm sure you'll have more questions, Mr. Slace.
Good afternoon, Judge Fisher, Judge Cardone, honorable committee members. I'm delighted to be here. I have sat through much of the testimony. It's clear this committee is curious, engaged, and focused on solutions. And I'd like to try and help. I think we have an excellent program in this district. In answer to the questions that many of you raised, I do believe it's reproducible. I don't think it's easy, but if you want to hear from us about what we think about the program that works, we're delighted to tell you. Briefly, I think it comes down to two things. One is we have a CJA supervising attorney here, and it's very important to note that she is a very, very well-respected member of the defense bar, has been a CJA lawyer for over 2 decades. We all know her. When she says a voucher is unreasonable, it's unreasonable, and none of us complains about it. She comes with inherent credibility. The court took pains to select her using our input, and that's the second big part of our program that I think works. We, as the CJA and criminal defense community, are involved in every aspect of court governance. Judge Gonzalez-Rogers has us sit on the CJA Administration Committee. We have a huge say in who gets selected. We have a huge say in who gets disciplined. We have a huge say in court policy. And a funny thing happens when you have stakeholders actually participate meaningfully. We then become responsible. We are responsible to the court. We're responsible for attorneys. We're responsible for ourselves. And I think one big concern that you have, and we acknowledge, is if there is some sort of more independent route here for voucher review, for CJA matters in general, are we going to abuse that as CJA counsel? Is there going to be any fiscal discipline in the system? And I'm here to tell you that the more you involve the CJA lawyers themselves in the process, the more we self-police, the more we are anxious to have overbillers off the panel, the more competent, good attorneys we want on the panel, the more the judges call us and say, Mary, this person's a problem, can you peer counsel that person? That's why our system works. We are involved. So I would like to evangelize on that point. I think it's the sole reason that we're involved, and we're involved in every aspect. We have a fee review committee here in this district, which we have not needed ever since Diana Weiss has been our CJA supervising attorney. We didn't need it in her predecessor's tenure either. And it's because those two CJA supervising attorneys are and were respected members of the panel. I would like to also pick one other thing you haven't really focused on. I'd like to bring it up because it affects the quality and the happiness of the panel and our overall efficacy. And that is when lawyers get in trouble with the court, as they do sometimes, even in a well-running system, there is no ability to have counsel for that lawyer. We don't have an ability to hire counsel for that lawyer. What we have done in this district is we, members of the bar, pool together and represent our colleagues pro bono. It shouldn't have to be that way, and I want to make a pitch to you to try and fix that problem. The other problem which you have focused on is rate, and I'll just say two things about San Francisco. We all know it. It is an extraordinarily expensive place to live. For the past 9 months, it has been the highest rent-paying area in the country, eclipsing New York by a very large degree. The estimate here is if you want to live in a 2-bedroom rental, you have to earn $155,000 a year minimum. And at $129 an hour, that's just not a sustainable hourly rate. The same goes for experts. The same goes for the case maxima. They're ridiculous, to be blunt, especially here in San Francisco. We cannot hire experts that match up with the U.S. Attorney's Office. They can hire experts at $600, $700, $800 an hour for a good psychiatrist. We have a ceiling of $350. We get outclassed constantly. Those things are inequities in the system that need to be addressed. And for fear that we're going to run rampant and wild on all of this, I come back to our structure. I think structure is everything. I think it is reproducible. I would have said before it's culture, but culture comes from structure. We're very proud of our culture here, but it's because we've developed this structure over 2 decades of trial and error. Thank you.
Ellen.
Thank you, members of the committee. It's a great honor to appear here in front of you today and represent the District of Wyoming. This is my 3rd year as the panel rep from Wyoming and my 10th year as a CJA attorney, which after listening to many of my colleagues, I feel like a newbie after 10 years. But I wanted to give you the perspective from Wyoming because we are such a rural district. And it's easy for me to put that on paper, but I wanted to kind of give you some examples to maybe put some better perspective on just what I mean when I talk about how Wyoming is rural. The city of San Francisco has 838,000 people. The city of San Francisco is 46 square miles. In Wyoming, we only have 500,000 people in our entire state, and our state consists of 98,000 square miles. So our CJA attorneys are expected to cover our entire state. Even amongst our CJA attorneys, I'm somewhat unique in that I practice from my family's ranch, which is about 7 miles away from a town of only 200 people. I live 30 miles away from a grocery store, and I live about an hour and a half one way to either of the courthouses in our district. The fortunate part of that is that for the majority of it, I'm able to drive 80 miles an hour to get there. So when I took a cab from the Hyatt, about a mile or so down here, it took me a half an hour, whereas I would have made it probably 40 miles in Wyoming, being able to drive 80 miles an hour. But I'm not the only thing that goes 80 miles an hour in Wyoming. The wind blows 80 miles an hour, and on my way to the airport yesterday, it was indeed blowing 80 miles an hour in Cheyenne, Wyoming, which makes it hard for me to stand up. And it also makes it difficult for semi trucks and trailers to drive down the same interstate that our attorneys drive down to access the courts, in that one of them tipped over a few minutes after, or was blown over a few minutes after I got by, which caused the road to be closed for several hours. My child attends the 5th grade, and there are 6 children in her class. There are no children in the 3rd grade. We have 3 judges in the District of Wyoming. We have 2 courthouses that have the physical ability to have a criminal jury trial, have the proper holding facilities. They're located about 200 miles apart. We have 1 federal defender office that houses 3 attorneys, and that's located in Cheyenne, which is in the far southeast corner. But even that federal defender is a branch office of the Colorado office. Virginia Grady, who is in Colorado, is our federal defender, and I can't say enough good things about her, but we don't have a federal defender of our own. We have 18 CJA panel members who make up what we call our core panel. Those are attorneys that we feel need to get enough cases to maintain their practice, but no one is able to make a living off CJA work in Wyoming. But it's equally hard to have a retained federal criminal practice. The very vast majority of our attorneys are sole practitioners. The one who belongs to the largest firm, I think there are 6 attorneys, and that's a remarkably big firm in Wyoming to have 6 attorneys in your office. Our life in Wyoming and the types of cases we have is also governed by our boom and bust economy. We are an oil, gas, and coal state. It was booming, and now it's busting. And There are criminal trends that go along with that. We also have the Wind River Indian Reservation, and it's located 3 hours from our courthouse in Casper and 5 hours from the one in Cheyenne. It alone is the size of Rhode Island and Delaware combined. And you could probably throw Massachusetts in there as well. It has a 50% poverty rate, a 49% unemployment rate compared to the 6% unemployment rate that Wyoming has as a whole. It has a 7 times higher crime rate than the nation, and the Department of Justice has singled it out to enforce and try to minimize violent crime that happens on the reservation. So many of our attorneys are representing people on the reservation, and they are located a long ways from their clients, from where the crime occurred. So why does this make a difference? Why should it matter? And it just increases our windshield time, and that somewhat skews our rates. It skews the statutory maximum. It makes it difficult for us to budget, and I know that's something the committee is concerned about these days. When I talk to the court or file an ex parte motion to the court to ask for an expert witness, I often have to consider that at least half of what I'm asking for is travel time to get that expert to my client, whether it be simply because there are not those types of professionals available in Wyoming, and I have to look to Colorado or California or Michigan to find a forensic pathologist to evaluate. And when I ask the court, we have to ask for twice as much as someone who lived in Denver and who had that ability. And it skews the numbers, and it skews how the court looks at it. Wyoming has tried many different ways to make that happen, trying to get our clients closer to experts. It's harder than it sounds. We have to work with the marshal's office, who has to work with detention centers, and the logistics of moving our clients around is almost as difficult as moving us around. A few years ago, the court determined that it would not allow us to travel, that vouchers would be cut for travel costs. The most disheartening phone calls I have ever received as a panel representative is from one of my colleagues calling me and saying, "Am I going to get paid to visit my client?" And that happened over and over again. However, after hard work, the court has reversed that policy, and in the last couple of months sent us a memorandum that says that is no longer, and the court now understands the fact that we need face-to-face time with our clients, and meeting with your client through a screen and trying to hold up their discovery through a screen just doesn't work. It makes it difficult for us to have training. We rely on our federal defenders greatly in Colorado to help us provide training. Our standing committee received a grant, but we're about out of money. Our small numbers makes it difficult to even have a brown bag lunch when we have 9 attorneys geographically close to each other and only a few of them can come. And because they're sole practitioners, the lights have to be off in their office for them to come to training. So we rely heavily upon our federal defenders to help us provide training at a yearly seminar. And they also provide us with a great amount of guidance. However, Wyoming has recently transitioned from administration by the federal defender to a court-administered panel. And we are still working on the details on that. It's relatively new, but we have recently transitioned to court administration. But overall, things are good in Wyoming. We have a good quality panel, and part of it's because we're so small. We have to see each other every day. Since we're geographically located, I see the same judge almost on every time. So we have to have a good quality relationship, and we have to be able to have that balance. But what I want you to remember when we're talking about policy is please don't forget the people, the boots on the ground, the people who are avoiding getting smashed by a tipping over semi while they're on their way to visit their client. They're the boots on the ground, and that's what makes this program work, is the hearts of our defenders, and that's a lot of what we've got. Thank you.
Bonilla Arguda.
Good afternoon, committee members. I have the wonderful joy to work in the District of Massachusetts. I'm their panel representative, and I also represent the First and Second Circuit in DSAG. Massachusetts has always been known for its wealth of intellectuals and wonderful practitioners. Our panel is composed of the most wonderful attorneys that one can meet. They're not only filled with heart and the joy of practicing as criminal defense attorneys, they're extremely well trained, highly educated, extremely hardworking, extremely competent, and in the end, all of their work, I'm sure, saves a lot of money by getting reduced sentences or getting acquittals, negotiating. The reality is that that takes time and it takes skill. All of these attorneys that work on this panel, they are vetted by a committee that's composed of 10 attorneys, some within the panel, the federal defender, as well as some attorneys, as up until this year, outside of the CJA panel. It is a vetting process that really goes into looking at what that attorney has accomplished or has done. Are there any issues with the attorney? And once the committee decides that that attorney should move forward, whether it's a re-up or it's a brand new attorney applying, then it goes to the judges for them to look and give an opinion and decide whether they're going to accept them or not. And so we have very, very good attorneys representing the criminal defendants in the District of Massachusetts, and I'm proud of all of them. However, in the recent past, in the past couple of years in Massachusetts, as I've written to you in my letter to this honorable committee, we've encountered some issues that in Massachusetts really were never heard of, and that's voucher cutting. And not just voucher cutting, but limiting the amount of money that will be allocated to the defense bar to pay for their experts, be it an investigator. I have provided the committee with the guidelines that back in 2013 were promulgated in Massachusetts and are to be followed by all panel members in Massachusetts. What I've come to find out, though, is that within those guidelines, as called in judicial policy, if a judge is going to be cutting an attorney or not providing the funds that the attorney is requesting, there should be some conversation or some dialogue as to why that cutting is being made, and some explanation, an opportunity from the attorney to be heard by the judge who may be doing the cutting. That's called for in the guidelines, but it's not always observed. So we have attorneys in Massachusetts that right now, they get cut, but they really don't know why, or they simply receive a blanket message of, you took too long. Those guidelines also call for the review of our bills to be looked at by the judge and for the judge to determine what is the reasonableness of this bill. Well, I suggest to you that in a lot of instances, the judge sees us in court. You see us how we perform. You see what we write. You see what was written, how it was written. And you can say, well, this person wrote rather well memorandum, made an excellent argument. So you see that aspect of it. That's what the judges see. But the judges normally don't see what is in the background, how long it took. How many times did you have to meet with your client? And a judge telling any of the attorneys, you took too long meeting with the client. Well, sometimes it takes a really long time and many meetings to meet with that one client. Number one, to explain what the case is about, to explain how the guidelines are applicable to their particular circumstance. It doesn't just happen. You have to be there for that client. You have to explain, because in the end, it's their liberty that is at stake. I get to go home. They don't. They're incarcerated, and they may be incarcerated for quite some time. And in order for them to understand, it takes an attorney to explain to them and guide them and help them. And not just them, but their families as well. So having a judge determine what is the reasonableness of how often you met with your client, Or what is the reasonableness of you, attorney, meeting with the family members? You're only supposed to meet with those family members if it's important to the case. Well, sometimes you have to meet with family members, and you're not just having a cup of coffee with them. You're actually explaining to them what is happening to their son or to their daughter, and what's to come, and how they can help, or what defenses, if any, you can talk to them. And I certainly don't want to be disclosing in my bill what I'm talking to those family members is about, so that the judge can determine whether it's reasonable or not. In my view, that part of the practice should be removed from the judiciary. It should be either an independent person or an independent committee. I know that some areas like San Francisco work very well. They have committees set up for their reviews. Some have federal defenders who do all the work, all the review. I'm not sure that federal defenders really want to be doing all of that extra work, but there are other alternatives other than having the judge determine what is the reasonable of the bill. And it's unreasonable to expect to have excellent representation by an experienced, competent counsel without paying for their services, a reasonable rate for their services.
Thank you very much. Ms. Bednarski, would you like to make a statement as well?
Both of us, Anthony and I, really advocate for the CJA billing and authorizations and the CJA panel selection to be independent and separate from the judiciary. We believe that things don't work well in our district, in part because the CJA supervising attorney that we have, and I realize a lot of districts don't have that, is a former assistant United States attorney and not someone who really understands the defense function. And we think that essentially that person needs to have more independence from the bench, so that, because we really have no advocate in the CJA office or on the district court. Our roles as CJA panel representatives are very limited. We essentially have access to some information, and I think the court is good about communicating with us new rules and things that the panel needs to learn about. But we're pretty much just communicators with the panel. We don't have any role in actually affecting change or affecting rules or having anything to do, let's say, with a new Form 26 that comes out, you know. So, but we also, because we work with the court and are both on the CJA District Court Oversight Committee, I think we have an appreciation for the job the court is trying to do in our district that got handed to the court, really in reaction to a huge problem that happened years ago. And like so many things that are trying to get fixed in the state of emergency, sometimes it's not the best structure that gets set up or the best organization. The court has reacted to some overbillers and to some, what I understand to be outlier costs, just outrageous costs, maybe vis-a-vis the whole country. And I think the court has tried to come up with rules as an answer to that and try to get the panel to follow those rules as an answer to that. But instead of affecting more zealous representation or better representation or more effective representation, I think what's happened is the panel has felt disrespected. The morale of the panel is terrible. I disagree completely with Judge Carter said about the morale of the panel or whether it's better or whether it was better than a year ago. We're not statisticians, but we've done a survey of the panel. 70 to 80% of the panel, on a scale of 1 to 10, with 1 being awful and 10 being the best, 70% of the panel say 3 or less as to the morale of their panel. 80% of the panel say 4 or less as to their personal morale in being a panel attorney. 50% say they've considered quitting the panel. We care a lot, and I think our district court does too, about zealous representation and good lawyering, but it's a toxic environment that's created kind of comments that we see about what the panel thinks the district court wants from that is to cut costs more than to provide zealous representation, and to deliver those costs more cheaply and efficiently, but not to do everything that needs to be done in a case to give the best representation to the client. Our answer, I think, is that we think if there was independence from the court so that people, when they submitted their bills, submitted them to an office independent of the court, that there would be more trust there and we could get past a lot of the problems that exist now. I've been in the federal system for 31 years. I started there as a young lawyer. I was a federal defender for 16 of those 31 years. I've been on the panel for 10. I'm in a law firm that has 3 other partners and 2 other associates, so I can absorb a lot of the painful billing practices because I have some people who can help me, and I have computer systems in place that sometimes help with those things. I would say in Los Angeles, our overhead is probably about $70 an hour. My law firm, it's higher, but I'd say for a sole practitioner, which most of the panel is, it's probably about $70 an hour. And once you subtract out what people pay in their taxes, they're probably left with about $30 an hour. I don't think people are using the panel as a cash cow, but I do think that some people are dependent on the panel, and there's reasons for that. I sympathize with the job that's been handed to our judges to try to rein in costs, but I don't think the fix is more rules or more onerous forms. I think we need to have a system, something like San Francisco has sounds good. I know that Portland has a system that also is independent of the individual judges deciding vouchers and bills and authorizations. And I'd like to answer any other questions of the panel, but that's all I have to say right now.
Thanks very much. Ms. Rowe, would you like to start?
Ms. Bednarski, I think I want to start with you. Can you hear me okay? Okay. You said that the morale of your panel is very low, and you also indicated in your written statement that folks are asked to not only record their time on cases, but they're asked to, or they're required to record their time in cases by the minute, like from 9:13 to 9:24. This is what I did. Did I read that accurately?
Right.
Okay. And my understanding also is that time is not compensated. Is that correct?
We're not allowed to bill for billing.
Okay. Can you give us a better idea as to, I understand the morale is low, I understand that people are considering leaving the panel. What is, you said that there's been a chilling effect on the panel. Can you kind of explain to us what the atmosphere is, what the culture is, what from your perspective as the panel rep, do you see is going on with your panel members?
Sure. Essentially, people feel like the rules and procedures that have pretty much continuously been poured down over the last, I don't know, I would say, Anthony, 2 or 3 years. We've been panel reps for 2 years, and it started before that, is chilling their representation and their ability to be zealous. And a common response that we got to what do you think about that, how do the rules and forms affect your zealous representation, is I have to think about whether I'm going to get paid for something before I do it. I have to think about whether or not a district court judge reviewing this for reasonableness, or people don't differentiate between that word and extended or complex, because I'm not sure they really understand those two separate issues, but they just think generally in terms of whether someone reviewing it will dock their pay or cut their voucher, thinking that it wasn't necessary, or they spent too much time researching it, or they spent too much time talking with their client, or the issue raised by Victoria, time talking with a person's family. I think there's a general feeling that these cuts are arbitrary and these decisions are arbitrary, and that someone other than them, who are charged with the duty of the effective and zealous representation of that client, is interfering with what that lawyer thinks is necessary to do for that client. Nobody is reading discovery for their health. Nobody is not going home to dinner with their family because they want to have one more conversation with a client's family over why that's the best plea offer you're going to get, or why the sentencing guidelines mean someone's talking about hundreds of months. Nobody's doing that for their health. And I think people feel really disrespected when they get these voucher cuts saying, well, we think 600 hours reviewing discovery in this wiretap audio video recording 100,000 page case wasn't necessary, but 300 was. I mean, what kind of arbitrariness is that? Nobody wants to spend their time writing down what bait stamp number page they reviewed from 912 to 918 because they think someone won't trust them later on that they really reviewed the discovery. So I think it's a combination of things that makes people feel like someone's trying to micromanage their judgment in what service to give someone.
Mr. Solis, I'm going to ask you the next question. Is it the same for the issue of seeking expert services, interpreters, or, not interpreters, I'm sorry, investigators or paralegals or forensics experts?
I don't think so in my experience. I think in our district, we do routinely get provided expert services, ancillary services. I don't think there's as much of a problem with that. I don't as much have experience with whether or not those bills are reviewed or cut, because I don't see those bills. I approve them and they go off, and I guess I don't hear any complaints from the third-party vendor, so I don't have a problem. I know we do have some issues with the ability to obtain experts for a couple of reasons. One is we can't pay them as much as the government can pay the experts, number one. Number two, in our district, we've had, it's less of a problem of obtaining the authorization to get the expert than to get that expert paid. In our district, CJA payments have been slowed down so much that there's vendors that won't work with CJA anymore. There's interpreters that have dropped off the CJA panel. I personally have had interpreters that I've contacted, I worked with for years that I thought were excellent. They said, oh, it's CJA? No way. I don't have time for all those papers and all the justifications and waiting forever for payment. There's also some, obviously we have a lot of drug cases. Every other day I get a new, can someone refer a drug expert to review this drug and do a drug analysis? Because several of the labs that we used to work with won't do it anymore. They won't get paid, they get their vouchers kicked back. So that is a problem. But as far as whether or not we're getting authorized from our district, the authorizations come quickly, the payments come slowly. And that has an effect on the ability of our panel to receive services from third-party vendors who'd rather just say, hey, the county pays us, the government pays us, the federal defender pays us. Everyone pays us but CJA, so no thank you.
Have you done any follow-up to try and figure out where the voucher gets stuck? I mean, what's taking so long?
CJA office won't pay them. It takes a long time for them to get paid, so they don't want to wait. And then there will be some minor error, so they'll reject it. And so for a large, like a lab or a large lab, they don't even want to deal with it. They're like, we have enough private clients or other public entities that'll pay us quickly, so we don't care, so we don't need your work. But the minor, the solo, like an interpreter or someone like that, they'll just say, I don't want to do it. I can't risk the whole day of work to then get paid in a few months from CJA. It's just not worth their time. So that's a problem we do have.
You mentioned, I think it's Mr. Windsor who testified yesterday?
Yes, Mark Windsor.
Mark Windsor.
He's
And
probably
his-
watching this right now.
And his situation. My understanding, and correct me if I'm wrong about this, but my understanding is that the topic that Judge Carter was talking about this morning was completely different than the topic involving Mr. Windsor. That what he was talking about this morning was, he said a handful, at one point he said 3 to 4 people who had been overbilling.
Yes,
And
those
that
are-
happened a number of years ago.
Those are totally separate issues. Mr. Windsor's issue is completely different from what happened a few years ago and the people that were scrutinized a few years ago. Those are different issues.
All right. So my question is this, that we've seen these forms that you have to fill out. I think it's a 9-page form.
I'm sorry, let me just clarify why I think those are different issues. I think with Mark Windsor's issue, it had to do with the reasonableness of the amount of work that he did. And with those other people, it had to do with their either overbilling or sloppy billing or fraudulent billing. It's really, they're
No, I
distinct
understand,
issues.
and I'm trying to differentiate. My question really goes to the issue of this incremental time billing that you have to do now, where you have to actually say, from this minute to this minute, I was doing this, where you have to fill out a 9-page form that says, this is what's been going on in this case. Did those procedures come after the overbilling scheme, if you
Yes.
will? Okay.
Yes, they did.
All right. So, and they have nothing to do with what happened on the reasonableness review?
No.
My understanding is that on the 2 examples of the reasonableness review we raised, neither person, nobody thought they didn't do the work. Nobody thought they hadn't spent that time or that there was anything inaccurate about the bill. It had more to do with whether judge thought it was worth that.
Right.
But our new 9-page form, I think that was born out of one of the billing issues we've had, where we had a panel attorney who was on a multi-defendant case. For his case, it was declared not extended or complex, so his $57,000 bill gets cut to $9,800, whereas some people on the same case, for those people who pled their clients out, it was determined to be extended or complex. And that created that was a problem. So now we have a new form that has us detail why we think our case is extended or complex, and we have to have 9 pages of justification every quarterly bill after the maximum is hit. So that's what I think happened.
Thank you. Sorry, I'm going to go to Ms. Curtis Palin. I want to just ask you a few questions. You indicated that that recently the CJA function has been moved back to the court, or moved to the court from the Federal Defender's Office. I don't know if it ever was in the court before, but could you tell us why that happened? If you know.
I don't 100% know for sure. I think the panel rep prior to myself had come to conferences, had met people, had looked at other people's plans and seen the detail in a plan, and had seen other districts developing these more detailed reviews of attorneys and working on quality of representation. So I think that was an issue. We had a larger panel at that time. We didn't have it divided into what we now call the core panel and the supplemental panel, so that attorneys who were trying to stay on top of the practice of federal defense felt like that they weren't getting as many cases to assist them in doing that. I think there were concerns about how the cases were being distributed, and that part of it was an effort to create a more written plan and court review of distribution of the cases to consider which attorneys got the cases.
So essentially you set up more of a structure.
Set up more of a structure, yes.
And have the attorneys, the panel attorneys in your district, been happier with that structure?
As far as I know, I mean, there's the inherent conflict that we've been talking about, in that it brings in additional judicial review of our panel members. And one of the things we still struggle with this plan is there is now a committee that consists of a federal defender, myself, and 3 other members who are appointed by the court. And when it comes time for us to review the panel members, that's difficult for all of us. It's difficult for the court. It's difficult for us to review our peers. And so that's one of the things that we continue to struggle with is how to do panel member review and on what we base that. So we're still, working out the details and how to balance that amongst the committee and the court, and who wants to step up and take that responsibility or communicate that to attorneys, and how we do that, and how an appeal process would work. And so those are the kind of things that we're still working on. Luckily, we have a pretty open relationship, but I think that our plan, the devil is in the details, that it's easy to have nice fancy plan language, but putting it into practical work is difficult. And so I admire districts that have CJA administrators. The problem is that Wyoming would probably never get its own CJA administrator. We don't even have our own federal defender. So to some extent, I fear creating our own separate branch, because I'm afraid it won't really be our own. It'll be us as a part of Colorado, and we'll lose that local control and that locality that Wyoming likes so much. That's part of our culture is the smallness.
Except for the area, right?
Yes.
Geography. You told us about all the windshield time that you spend, and then the court trying to limit that by saying they wouldn't pay you for travel, and then reversing on that. Have you seen issues with the bills, since the bills are, as you say, sometimes, I think you said 50% travel, have you seen issues with the courts cutting your vouchers because of that?
Not, initially, yes, there was that concern, and that vouchers were cut. And then the court explained why they were doing that, and that the court felt that the attorneys were traveling too much. The Marshal Service in Wyoming has a contract with Scottsbluff County, Nebraska. So our Cheyenne attorneys and the majority of the clients handled in the Cheyenne court, in fact, almost all of them are housed in Scottsbluff, Nebraska, which is 2 hours. And so it was determined that you didn't need to go to Scottsbluff more than once or twice to meet with your client, or that you could meet with them, you could have the Marshal Service transport them to Cheyenne and have the Marshal Service pick that up. The problem with that is that there's not a place where you could have a face-to-face meeting with the security was such is that you couldn't have a meeting with a client except for through the screen. And so I think what vouchers were being cut, attorneys were upset. Some attorneys left the panel for that reason. But I think we continually push that issue. We continue to try to work with the Marshal's office. We continue to try to explain to the court why face-to-face meetings were important and why we needed to go to Scottsbluff. I think there were instances when a client got to a change of plea, and when the judge asked if he was happy with his attorney, the client flat out said, I haven't seen him except for today and maybe at my initial appearance, and we've talked on the phone on an unsecure line. So I think time and experience helped us all to realize, and maybe more of an understanding of the CJA panel attorney's role and an understanding of what our relationship with our clients have to be. But it took time to make that happen. And now I haven't heard in the last 6 months or so that vouchers have been cut because of travel. And the court did produce a formal memo to distribute, because there was still that fear among attorneys. even though the court hadn't been doing it nearly as much, there was still that fear among attorneys about, do I have to justify this? Do I have to explain? How much explaining is enough?
Thank you.
Follow up with you, Ms. Curtis Palin. That policy you said was instituted a couple of years ago?
About the same time as the transfer of the administration of the panel to the court.
Okay.
So about 3 years ago.
Roughly the same time as sequestration as well? Then.
Yes, yes.
And do you know, did that policy, the limitation of visitation with your clients, originate with the district court or with the circuit court?
It was the district court, sir.
And was there any consultation with the panel before instituting that policy?
Not that I am aware of.
Do any of your judges on the district, and I assume this was the district judges who decided upon the policy?
Yes, and I think it was more prevalent among certain judges than others.
Do any of those judges have experience as criminal defense attorneys?
Not that I am aware of.
Thank you. Ms. Bednarski, I'd like to ask you about a choice of language you used a little while ago, because and that was rein in costs. And I think Judge Carter might have used similar language when he was testifying. And I'd like to know if when you were using that language, if that comes from any particular place, if there's a reason that that language is being repeated in testimony. Can you give me any insight into that?
Well, trying to understand from the court's perspective in our district the need for all these incredibly minute rules and what all the lawyers think of as micromanaging their decisions in the cases and their billing. And so in trying to put into context why the court felt like it needed to impose those rules, of course, I have access to information because I'm on the District Court Oversight Committee and the Circuit Court CJA Oversight Committee. So I know that they were very concerned about costs in our circuit, in part because of these extraordinarily huge cases we have, involving 50 defendants, 100 defendants, unbelievable amounts of discovery. And it's not just those cases. I think someone mentioned earlier this morning, it's kind of hard to define what's a mega case. Like I had a 6-defendant case where mine was the only client who went to trial, and it clearly was a mega case by virtue of the amount of audio and visual recordings and the amount of work it took to get it ready. But it wasn't a 50-defendant case, and it wasn't a 3-terabyte case or anything else, but clearly huge. So I'm just trying to understand from the perspective of the court why it feels all these rules are necessary, because of course, our perspectives are so different. Like Anthony and I, our blood was boiling when we heard Judge Carter, testifying to his opinions about the morale on the panel and the reasons for the rules and the effect of the rules, and basically saying, people are adjusting and the new lawyers think, they're adjusting and it's fine. Well, they're not. And they are amongst the people who we've surveyed, and their morale and their criticism of these rules and these billing practices are just as vociferous. But I always think that it's a good idea to try to understand where things are coming from and not just react to them and say, oh, they're vindictive or punitive, or they hate the defense lawyers or whatever. So that's why I chose that language. I do not think that the rules and policies and procedures are making representation better, and I do not think that it's going to stop fraudulent billing. If there's always going to be people who, because we're human, I think there's always going to be people amongst any group of people who don't do things right, and none of us want that. But the problem that we have with, say, the rules requiring you to keep track of these minute time periods, or the rule that you have to document what page number you've looked at, or the rule that you have to now on this CJ 26 form write down the cases you read. Nobody Nobody will remember the cases they read, unless maybe it's one of the ones that ended up in your brief that was one of your best cases that you thought was going to help you win your motion. You're going to read 50 cases that never make it into a brief. So people feel like these things are punitive. They are not helping defend a client, and they are only causing people to not want to submit their bills or not hassle with it. I filled out the CJA 26, which just came a couple weeks ago, I think, or 3 weeks ago. So I filled it out on one of my cases that just ended. And I put my timer on my phone to see how long it took. And when I got to 108 minutes and I realized that I couldn't do any more without looking at my actual files and materials back in my office, and probably to complete the form, it was probably going to take about another 2 hours, I thought, this isn't fair. I'm being asked to repeat information that I have put in all my vouchers, but I'm being asked now at the end of the case to recall, and in my case it was only 8 months ago. Most of these cases last years, but even at an 8-month basis, I'm not able to recall why did I need to spend that much time reviewing this certain batch of discovery as opposed to that? Why did I need to spend so much time researching this motion, which I might have rejected in the end and not even filed? You move on to other things. And to ask me to go back and spend hours essentially justifying what, after 31 years, I thought was a good use of my time is frustrating at best.
I have a follow-up on that for you and for Mr. Solis. Are you able to provide us with any sort of estimate in relationship to your overall billings, your overall CJA billings, the amount of time spent upon administrative requirements necessary to bill, 2%, 5%, 7%?
Way too much time.
I gather
tell-
that, but
I'll tell
remember,
you,
we've got to write a report and we've got to
I
make
understand.
recommendations, and so that's why I'm asking for
I
something a little more
would
specific.
probably estimate it to be about 10 to 15%, because there are so many layers we have to do. We have to first log our time on a written sheet. That has to be marked by the minute that we started and the minute that we ended, and it's got to all be on a sheet continuous throughout the day so that CJA can check to make sure that those items were possible to do in a day. Then once we do the vouchers, even though all the vouchers and the worksheets, we've input all the information, we then have to still do this every quarter, this 9-page sheet, and list all the cases that we looked at, whether we use them or not, because the CJA office clearly wants to check to make sure if we're billing for something that we actually looked at them. I really hope they're not looking at all the cases that we looked at to make sure they're relevant.
So what's happening to those contemporaneous billing records, those minute-by-minute records? Where do those go?
They go in a file where they are audited by Judge Fisher. 3 every period of time, I think it's either month or quarter. 3 attorneys will get audited, and there's an effort to make sure that the time is being kept in the manner that the court expects it to be kept, and that they're legible, and that they're actually contemporaneous time notes. However, I will say that I have seen some examples of some of them that are abysmal, but for the most part, we have to keep them, and they're subject to audit.
Do you maintain a retained practice at all?
Yes, I do.
And can you tell me, what are your billing records like in your retained cases?
They consist of a few notes I scribble in my file and the bill that I generate for my client. But I will tell you, in 17 years of practice, I've never had a client ask me to list which cases I looked at, whether or not I put them in my motions or brief, or whether or not I filed the motion or not. So, I will also say, my bills are fairly explicit in my retained practice. Many of them are flat fees, so I don't even deal with that. But my bills are such that I can't remember ever having a significant billing dispute or someone asking me to justify the type of billing in almost any way, and it's certainly not the way that the CJA requires me to do it. Though I do recognize it's different. when you're dealing with private funds and public funds, and I do appreciate that.
Ms. McNamara and Ms. Bonilla-Aguado, my recollection is that both of you maintained significant retained practices. So could you describe for me the way in which you maintain records for your billing in the retained cases?
Yes, and I think that's a great question. Thank you. I do work for corporate clients, privately retained individuals, CJA, different types of civil representation. And I can tell you, even for our, it seems like less onerous billing sort of protocols here in the Northern District, what we do on our CJA cases is much more onerous than I do for a Fortune 500 company that's very bottom line oriented, very audit prone. I have had the experience commonly from Fortune 500 companies of getting a thick wad of documents telling me what I can and cannot bill for. They're very clear, but I do not have to submit the kind of CJA 26 that the Central District has, nor am I told that I can only hire an expert within a certain fraction of the market rate. Nor do I have to submit vouchers in the detail that I'm required to here. So I can just say that here in the Northern District, we do all of these things, we do it gladly, but it is at a standard higher than is generally the case in corporate America. That's number one. Number two, can I just say again, the billing rate that we are paid is a fraction of what I get paid for my corporate clients. So the amount of work that we do in billing, non-compensable, is a lot. It should be enough to permit a reasonable audit. It is higher, the standard is higher in terms of the detail and specificity than we have in any private practice. For an individual client, I do what I do with all my clients. I keep contemporaneous typed records in my timekeeping system. I bill to a six-minute increment. That's my personal standard. It's what we do at CJA. I budget for clients when they ask for it. I do all of that, and still what we're asked to do in CJA is more onerous.
Ms. Bonilla, would you mind speaking
Both
to that?
in my private practice as well as in my practice where I accept appointments, whether from the state or the CJA panel, I keep the same billing records. And that is a contemporaneous record of the time that I have spent, whether it's in court or out of court. I write in it what I have done, research or investigation. I'll write some notes as to what was it I was researching or interested, perhaps a motion to suppress or a motion to dismiss. And I would write, I do not go into length or detail as to each and every case that I've researched. And I do bill my clients, whether I bring the motion to suppress forward or not. I do bill them for the motion to dismiss, whether I bring it or not. And I sit with my client and I explain to him why I did the research or why I thought that they had a potential viable motion. And I get paid for my time and my work, and it is a contemporaneous record of what I'm doing.
Ms. McNamara, I want to just one last area before I move on, and I want to ask you about a statement you made in your opening statement, because it's an area that I'm very interested in. You talked about the interrelationship between culture and structure, which you can imagine as a sort of chicken-egg problem, and we're concerned with things that we can scale, that we can transplant to other places, that we can make work. And while I heard you talk a lot about structure, and I heard your chief judge talk about that as well, I also heard you talk about things like culture and respect and particular people in particular positions. And so I'd want to know if you could just give me a little more detailed answer on how you think that structure can move from the Northern District of California to, let's say, the Northern District of Alabama and function well.
Yeah, it's something I've thought about a lot. I think culture comes after structure. I don't think you can get a good culture without a good structure. I think it comes here from the fact that it is written in our CJA plan document and in our General Order 50 that the CJA representative is on the key committees of the court, on the CJA Administration Committee, as is the federal defender, as are other members of the defense bar who are experienced. We have a fee review committee that comprises solely criminal defense practitioners who are CJA members, chaired by me as the CJA, CJA representative. We are on, as a matter of course, the CJA Supervising Attorney Selection Committee. We are on, as a matter of course, the panel committee that screens, investigates, does due diligence on every single panel applicant to our district, and we are invited by the court to discipline lawyers when and if the need arises. Those are structural elements, they're in documents, they're transparent, our panel knows. The second part which comes from that is what does that structure beget? That structure begets our hiring a CJA supervising attorney who is one of us, who people have confidence in. And I understand that there may be a dearth of applicants for that job. I think that's a big problem. I think it can be fixed. I think there are outreach efforts you can do for recruiting. We have ideas about that. But I think it's key that the person who holds that position is not a former prosecutor. Somebody who holds that position should be somebody who can speak truth to the panel and will be accepted. I think the other thing that comes from that structure is an open door policy on the part of the court. I know that if I have an issue, I can call up Judge Gonzalez-Rogers or Chief Judge Hamilton, and they will take my call. But those things come from familiarity with us. The other component of it is, and this is something I do want to stress, is when you have that structure, the court expects us on these committees to discipline our peers. That's a really key element, and I can give you a concrete example of how that worked in our district. There was an attorney, a very, very valuable member of our panel. Many of the judges thought he overbilled, thought his bills were excessive, unreasonable. Instead of simply arbitrarily cutting him from the panel, they came to us and they said, we have a problem with this person. We want you to look at it. Tell us, do we have a real problem here or not? We looked at the issue. We could see where the judges were having the issue. We peer counseled that person. The person changed his billing practices. That person is now a fully respected, happy member of our panel. The judges enjoy his work. He turns in excellent work. I think without our structure, that sort of situation could have been combustible. It could have led to rancor. It could have led to somebody being summarily dismissed from the panel and then infecting the attitude in the panel towards the judiciary. And if there's one thing I could say to this committee, I think that having us involved early in committees, heading off those problems, translates to a culture of collaboration where we on the CJA panel trust what the bench says because we know where it's coming from. We've been there when those things have been decided. And on the other side, the judges come to us and say, here's an issue, help us. So it is a feedback mechanism that works. And I've seen it, just to give you an analogy, in private practice. We talk to management consultants, failure analysis people all the time on our cases. And we ask them, there's an accident or an incident, it's bigger than that particular issue. How did this happen? How can we tell the company to prevent it? How can we educate the company into how to handle things in the future? And what every single professional will tell you is having a feedback mechanism where you have buy-in from the stakeholders is the only way to do it. You cannot hand down policy from on high and not involve the stakeholders in the resolution or the policing of the program. It just doesn't work. So when Judge Gonzalez-Rogers talks about collaboration, it's real. We feel it. The system is never perfect. Sometimes we do have overbillers, but we're not in an oppositional relationship with the court when that happens.
Do you have time to talk about one more thing? Or so something that you just said spurred me to ask this question, but I really want to address it to everybody. And that's the question of reasonableness. Because as somebody who's never been a panel lawyer, I frankly don't know what that means. I think if I do some work on a case, that I've done it as an exercise of my reasonable professional judgment, so I don't really understand what's going on beyond that. So I'd like to know if you could explain what you understand, what you believe is going on when that level of reasonableness review is happening, because
Yeah.
I don't understand.
If I could take the first crack at that, not to be profane, but I think it's like pornography. You know it when you see it. It's very hard to define, and I think it comes down to pretty broad strokes. I can tell there may be differences in how I personally practice as compared to somebody else. But I think within certain sort of broad boundaries, I recognize that somebody who does perhaps more in a particular area than I is still behaving reasonably. But we can see at a minute's glance what's unreasonable. We can see when people are billing hours upon hours upon hours for reviewing transcripts day in, day out. That's a red flag. That requires us to say, well, what exactly were you doing? That's what Diana Weiss does a lot. She will come to a lawyer and say, I see here you spent 3 days reviewing transcripts. Tell me what you did, why it was necessary, how it affected your case, why you needed to do it. And if she doesn't hear a compelling explanation for that, she'll judge it to be unreasonable. So this comes, I think, from a certain taxonomy of reviewing vouchers. You know, Jerry Tritz, Bob Rance, these people are professionals who do this day in, day out, and they see patterns. They can tell you instantly what's a red flag. A person who does, point one for reviewing vouchers, that's somebody you need to investigate. The endless stream of reviewing, that's someone you need to investigate. There may be explanations, oftentimes there aren't. That's the kind of thing I think that you can judge to be reasonable versus unreasonable. What Marilyn was talking about, going to see your client too much, that is never judged as unreasonable in our district. That's what we're supposed to do. The court expects that of us. And, Judge Boulware this morning, I was applauding what he was saying. In order to take on these heavy criminal cases, reasonableness demands that you build a relationship of trust with your client, because you're going to be telling your client at some point, if you go to trial, it could be a life sentence, or I could get you 18 years. Be happy with that. If you haven't visited that client and established a relationship with trust, you're going to go to trial, which, guess what, will cost the court a lot more than having somebody who's invested the time up front. It's a long-winded answer, but I do think professional people can easily spot the danger areas in bills.
Maybe I'm being unfair, or I'm being overly reductive, but it almost sounds to me like what you're saying is, on the one side there's churning, on the other side there's real work being done to advance the case. Is that what you're telling me?
Yeah, that's what I'm telling you.
Mr. Solis, do you agree with that?
I don't know what kind of standards are present to determine the reasonableness of a particular bill. I know that I've never had a bill that has been reduced for being unreasonable. Maybe I'm lucky, maybe I just don't waste my time doing certain tasks that are going to cause red flags. But I do know that there are certain things that our court will set or determine that is unreasonable. For example, talking to a client's family. So if a particular development happens in a case and you want to tell the client's wife, you won't get compensated for that, because the court will consider that hand-holding, even though that relationship with the client's wife or mother is going to go back and increase confidence in your client. That's a core function of our ability to communicate with our client, build trust with our client. It's something that the public defender's office in the Central District does routinely, but we're discouraged, we're chilled from doing it as being, that would be unreasonable, because we're just giving information that's not for the case. The court is also discouraging us from traveling to see a client. If that would create a burden on a client, we have to have extra justification to travel to a client who's out of custody. We have to make sure they come to us, even though in our giant district, They will have to come very far, maybe spend 2 hours on a bus, and it'll cause all kinds of problems in their life. If I want to develop a relationship with my client and say, I need to come and talk to you about the case, don't travel 2.5 hours on a bus, I will come to you. That's going to be unreasonable because the court wants that person who's receiving public funds to expend every possible dollar before we have to spend any money. And I think that deteriorates the attorney-client relationship to some degree. Yes, we could justify it. If my client's in a wheelchair, I could say, yes, I can't make this person do it. The court will probably pay it. But the dictate is that is unreasonable unless you tell me why it's not. They don't have those calculations in the Federal Public Defender's Office, so it's different. The calculus is different.
Ms. Curtis Palin, could you talk about that same issue? I'm just trying to get a grip on this. I really don't.
I agree with Ms. McNamara in that there is somewhat of a line in determining reasonableness between written materials and legal research and dealing with clients. What's reasonable in dealing with a client oftentimes depends on how reasonable your client is. You have to gauge each client differently, whereas some clients can have a meaningful discussion with you about the sentencing guideline, and your next client is screaming at you and beating their head on the table. It really varies, and your communication with your client depends simply a lot on their personality, and it's very hard to judge that without looking at a case-by-case basis. There's a clerk of court in our district who works with us on vouchers and prepares them for the court. We turn in our vouchers to him, and he puts them together, reviews them briefly, and then passes them to the court for approval. And he always tells me that he defines our attorneys as there are research attorneys and there are non-research attorneys. And after reviewing the bills, he kind of has a feel of which attorneys feel like they need to do research and that is a reasonable part of their practice, and which attorneys rely less on research and book work. And I think that's just a practical manner of getting to know attorneys and their personalities and how they practice and what they feel is reasonable within a case. So it is very difficult to judge. You know it when you see it. Part of it is you know it when you see that person standing next to their client and how the court proceedings go. And in that, there is some value to judicial review because I don't see my colleagues or my peers in the courtroom very often, but the judge does have the ability to look at the client and the attorney in the eye and kind of get a feel from a plea colloquy or a sentencing kind of that relationship and the reasonableness of the case.
Ms. Bonilla, what do you understand to be happening when
I can only speak
voucher is reviewed?
as to myself. I do not review vouchers or the panel attorney vouchers, so
No, I mean, when you send your voucher up, what do you think is happening to it?
I think that it's a very reasonable voucher, but obviously sometimes the judges may not think so. But reasonableness to me is that you're doing your job and that you're doing your job in a competent manner. The issue also comes that the reality is we're not just expected to do a competent job. We're expected to do it at a cost saving. I'm just asking the court not to ask us for the China price. We're not Walmart. We're professionals. We're doing our work. We should be, in my view, trusted to decide what is in the best interest of our client, how to best represent that client, and what is needed to represent that client. All of those things, to me, are reasonable, and if the attorneys are doing those things, as well as investigating, meeting with people, getting a feel for what kind of a trial I may or may not have, and explaining it to the client, all of that is reasonable.
The question I've got is that what you think your judges are doing right now, or are they doing something different?
I can tell you. There's a line item, and perhaps the attorney didn't explain the line item very well. I believe that it is unreasonable for a judge to take the position that that line item will be diminished 15% because the attorney did not write a good description of however they spent their time doing. So I think, from my perspective, that the judges believe that a case has a value in their mind. And when it exceeds that value, then it becomes a questionable voucher. And I think that's wrong for a judge to do that. Each case is different, each client is different, and attorneys should be researching, attorneys should be investigating, attorneys should be meeting with their clients, and I don't think the judges should be in the position of saying how long to meet with the client, or who to meet with, or to micromanage, or to shut down a database a few months before trial. Those are wrong things.
I want to see if we can take a look at the other side of this. And I'm talking about, in specifics, the CJA 26 9-page form that's causing so much discussion, but the broader picture. But before I ask my questions, I want you to know I'm not unsympathetic at all to having a client question a bill. Last civil case I was involved in, last trial, I left a pint of blood on the floor like you folks do, and the client questioned my bill for 3 days, cut it. I've been through it. It's devastating. So I'm not unsympathetic to what you're saying. And it's devastating mostly to your morale. So I'm from Philadelphia, but I live north of Philadelphia, a smaller area. And a lot of my lawyer friends represent small clients, not corporate clients. Individuals, let's say, in custody cases, small businesses, important litigation, maybe not comparable to the liberty stuff that you folks deal with, but custody cases are important. The lifeblood of a small business is important. And I have a lot of friends in the Philadelphia area who represented Fortune 500 companies, like you, Ms. McNamara. All of them, and this was my experience in civil practice, all of them is an overstatement. A lot of them constantly complain to me that their clients are micromanaging their billing, that they're having to go to their client's office and sit there for hours and hours and hours. And by the way, they can't bill for this and justify what they've done. They have to write reports. Fortune 500 companies, that was certainly my experience, and a parent who's in a custody dispute. They are in constant battles, even to the point of litigation, where they have to sue their clients because there's been such extreme cuts. So my question is, understanding your fee is a lot less than theirs, but you're dealing with public money, so that may balance it out. Why are you folks different? Yes?
I don't think we are, and I don't want anything that I've said to imply that we're different. I think there are two...
Why shouldn't you be held to the same standards as other lawyers who work for a fee?
I think we should, and I think our district does that. I will say, I think CJA billing is at the more searching extreme of what we see in the private sector. I can tell you, I've had to justify my bills just in the manner you've described to corporate counsel. They said, what the heck is this? But I think the key distinction is who we are as lawyers. We deal with criminal cases. Many of the panel members are in and out of court the entire time. And it's not just that they have a federal CJA practice, they have practices in state court, they have practices all over the place. They are solo practitioners, many of them. And so for them to go through the bureaucracy, and it is that...
You just described most domestic lawyers in small counties. They run from courtroom to courtroom. They represent clients who are in struggles, I'm over-dramatizing a little bit, struggles to maintain custody of their children.
Right. And I've been in those kinds of courts too. So I tell you that I think what the CJA is requiring us to do is at the more extreme end of what happens in the private sector. I don't complain about that. I think what we do here is appropriate, and we are really sympathetic to the bench's need to say, you're spending public money, be responsible for it. But I think it's gone beyond that in other districts, and I think it is beyond that by a considerable degree in the central district, from what I'm told. And so I think, yes, we need to be rigorous and defend what we're doing, but when it gets down to you have to put in your precise time, minute by minute, I don't know of any private client who would require that, nor do I know of any private client who would ask me what cases I reviewed in a 9-page form at the end of the case. Those things, I think, are too far. And I come back to what Ms. Bednarski said. I think the solution to the issue is not more rules that sort of alienate people, but more of a sense of inclusiveness so that we self-police. When we submit a voucher in the Northern District, we talk to Diana Weiss, and we say, Diana, here's what we would like to ask for. Do you think that's reasonable? And she'll either say no, or put, item A into item B, or she'll say, yeah, I think it's reasonable and I will advocate for it. And that is a beautiful system because it answers another question you've asked, which is uniformity. Diana sees all of the vouchers in the district. She talks to all of the judges. She knows what's what, and she knows that from her experience. So, we have a feedback loop in our district that inculcates best practices so that we don't run into the problems you're describing. We don't run into the thundering corporate council saying, what the heck is this? All of that is headed off at the pass early on because of our CJA supervising attorney.
But seems to me there's a bigger problem in their district. So let's hear from Ms. Bednarski and Mr. Souls.
Sure. Well, I have private clients and I have CJA clients, and some of my private clients question bills and want to make sure, for instance, if there's co-defendants, that the lawyers aren't duplicating their time, that they're working efficiently and they're not getting double billed by this office and that office. And we defend our bills and we work things out if we can. I mean, sometimes it's just easier to work things out, especially if you're going to continue with that client. What I think exists, though, is a trusting relationship. And I think what exists is this kind of communication and collaboration. And what I hear is really different in the Northern District is there is someone who comes to the lawyer to have a discussion about why is this reasonable, and asks for an explanation. And I've done some reasonableness reviews myself as a courtesy to the court over the past several years, and did it with other groups of people, and it takes an extraordinary amount of time. And what I learned from that process is that I have my own opinions of the way I would litigate a case, but someone else might well litigate it differently, and that I have to remove myself from my judgment about how I would have done something, but still find a way to make an estimate of what's fair or what's not fair. And what we kind of came up with in the several reasonableness reviews we did is there's sort of a range of time within which something could have taken place. If you worked on a motion, maybe it was 2 hours or maybe it was 6, but nobody could say this was worth 3.2 hours. But I think the important thing is a sense of trust and the sense of independence from the strategy and litigation of the case. And that's what's so different about having an office like theirs that's independent really from the bench, and why it works, I think.
Thank you. I don't know anyone on our panel, on this panel, in this room, who doesn't see oversight as a critical function when you're dealing with public money or even private money. There should be vigorous oversight. The question, from our district, is how much? How much? How many layers of record keeping and bookkeeping and minute by minute and not this? By the way, this CJ 26, every quarter, every case, cumulative. It requires case law. And if you haven't looked at it, look at it in detail.
I have looked at it.
So the question isn't whether or not you need oversight. It's how much How much before it becomes such a burden, we're starting to lose panel members to say, I don't want to deal with all this paperwork. I don't want to deal with all these burdens, because I hear and I share all these stories because I come to these conferences that we're having in the district conference tomorrow. People are saying, well, we only do a 2-page thing. We don't have to do half of those things. So then the question comes back to what Ms. Bednarski said. It seems as in our district, the trust that the court has for its own panel members is at its worst ebb. Because if there was a greater degree of trust, this would not be 9 pages in every case in every quarter. And we wouldn't have the avalanche of paperwork just to justify work that, by the way, we've already put on worksheets and vouchers, and it's available to anyone who wants to look at it within the court reviewing our system. So it's not a matter of whether we think we're better or whether we think we should be beyond review. It's how much is enough to determine that our work is reasonable and how much becomes a burden to us.
Maybe like most problems, maybe the answer is somewhere in the middle, where the sweet spot is. I have one more quick question, and then I'll turn it over to my colleague here. In your submissions, and I'm sorry to just focus on the Central District, but you say on page 5.3, in our district 2015, we had 2 celebrated instances of significant voucher cutting. Were there instances that you're aware of where significant vouchers, for whatever time period you folks want to pick, where significant vouchers were submitted and weren't cut? I mean, you've cited 2 problems. What about the rest of them?
Absolutely.
Yes.
Absolutely.
No cuts.
People submit vouchers and get no cuts.
I get no cuts.
Okay, thank you.
Oh, and but can I just follow up that?
Sure.
The issue is not cuts. If you look back on page 5, number 3, it's arbitrary voucher cutting. Those 2 examples have to do with arbitrary voucher cutting, where the judges don't have to explain why they're cutting someone's bill by 1/3, and there's no review process.
Thank you. I'd like to ask a series of real quick questions and hopefully get very quick responses from you, if I may. Ms. McNamara, an issue you've mentioned several times and also in the written material, but I would like to hear from everybody on this. Hourly rates. You say they're not enough. We've heard this repeatedly. I'd like to know what all you think hourly rates should be, and should there be some kind of locality adjustment for that?
Yes, definitely locality adjustment, I think. And I think that is how the Department of Justice handles people who get seconded to San Francisco or New York or some other high cost of living metropolitan area. If you were to ask me what the hourly rate should be, I would say let's do a study on it. And I'll just throw out a couple of figures. For civil representation of federal defenders, which I sometimes do, the hourly rate for that is $200 an hour. That's for civil representation. That's telling. It's a figure I'm just throwing out. Here in San Francisco, a person with my level of experience, trial experience, complex case experience, we get complex cases here, the rate is anything from $500 to $750 an hour. I'm not saying it should be anywhere near that, but those are 2 benchmarks that I think are telling. I think there should be a study on it, and I think we should figure out what's appropriate and maybe model ourselves somewhat on what DOJ does when it sends folks out here to handle cases.
I think some study has been done because the congressionally authorized rate is higher than the current rate now. I believe it's 144. Why is it not that for us? I don't know, but somewhere that number 144 came about, so it should definitely be higher. Whether or not, and whether or not it should have a locality, of course it should. You can't, San Francisco and New York and Los Angeles are just qualitatively different than Wyoming. So why should the rate be the exact same? Because the costs, the overhead costs, the cost to do business, the cost to be a lawyer in those places are just not the same. So they shouldn't be the same, the rates.
Ms. Curtis-Palin?
Our overhead is lower, but we're providing the same quality of work. We have the same education. We are the same caliber of attorneys as an attorney in New York or California. We may have lower overhead, our cost of living may not be as much, but we are just as powerful of advocates for our clients as any attorney in the nation.
So
Was 129 an hour okay, or does it need to be higher even in Wyoming?
I believe it needs to be higher even in Wyoming. Civil practice custody attorneys, like I do a lot of custody work myself, my rate's higher for a custody case. It's about the same for state-appointed work in juvenile court, for example, or state-appointed work, it's about 125. But for private cases or, you know, DUI cases, a county DUI case, it's higher than what I receive for my CJA work.
Okay, how about Massachusetts?
Massachusetts has some expensive attorneys, sort of similar to San Francisco. You have attorneys in Massachusetts that are charging $600, $700 an hour. You have attorneys charging $200 to $400 an hour. I do believe that our hourly rate for the CJA panel should be what has been mandated or granted by Congress, $144 an hour. And I do believe in locality changes due to where the offices are located, the states that those offices are located in. And I believe that 18 U.S.C., I mentioned it in my submission, I think it's 18 U.S.C. 3006 AD1 allows that for there to be different rates in different localities, similar to what federal defenders have, similar to what U.S. attorneys have. It could also be done for the CJA panel if what we're looking for is a cost containment measure as to what attorneys are getting paid.
Ms. Bednarski, do you want to weigh in on this?
Well, I think even if it was 144, it would be too low, but I still think you would get really good people who are really committed to do this work as long as the job satisfaction is there.
Okay. Let me talk about hourly rates on a different note.
Coming back to that, don't we?
Service providers, Ms. McNamara, you said $3.50 an hour is not enough here in San Francisco.
No, it's not.
What should it be?
I think it should be for psychiatrists who are forensic psychiatrists and expected to testify, it should be what the Department of Justice pays. And that's what I understand is $600 to $700 an hour. And let me just tell you, walking into court with a poorly written report, poorly researched, with somebody who cannot testify is really difficult. And it is automatically going to lose you your point. It's useless to us. We've had people say to us, well, your expert is a hack. Well, we can only afford a hack. I'm sorry to be so blunt, but that's the way it is. And, you know, again, the cases where that kind of expertise is necessary and where somebody has to testify are relatively rare, but they're very important cases. So for mental health experts, it absolutely needs to be higher. We rely right now on sort of the goodwill of people who are willing to donate some of their time. That's not okay. For investigators, it needs to be higher. Our highest rate for investigators is $75 an hour. The usual rate here in the market is $175, $200, $250 for good investigators. You get what you pay for. You get people who are more efficient, who are ethical, who can testify, who advance cases. I say you invest in people, what that will produce is a quicker resolution to cases that should be resolved and a better trial for those that can't be.
I'm not going to go around with everybody else because I want to ask two more questions and give the rest of the committee time. Real quickly, changing totally on you. Does anybody think the Court of Appeals judges should be involved in reviewing excess vouchers? Anybody?
No.
Okay, I didn't think so.
I'm sorry, I wasn't sure you heard me. No.
Been very quiet, so we were.
And then
We weren't sure.
I want to direct a question to Ms. Bednarski. If I understood you correctly, you said that some of the attorneys are so disenchanted that they're not submitting their vouchers, they're not submitting bills. Did I hear you say that?
We have people who definitely aren't submitting certain areas of billing, such as because they think it's going to be docked and they think the voucher is going to be kicked back and they think it's just going to slow things down, even though they really believed it was essential work and important work. I know of a couple people in our district that just don't submit bills at all. And I think that happens in every district. I think there's people who just don't want to deal with the hassle of it.
Well, that was going to be my follow-up question. Could I just see a show of hands? Are you aware of that happening in your districts, that people are self-cutting their vouchers?
Yes, I've had anecdotally, because as the panel rep, a lot of attorneys call me and tell me what happened. One panel rep cut his bill by a third, thinking, if I cut it by a third, it'll be so palatable that it will then immediately get paid. And then it was cut further, and it didn't get paid. So then a battle ensued. So I encourage now, don't do that. Just bill the full amount, because then the court knows how much these services cost. Don't self-edit. But there are attorneys in our district. There's one I know that Marilyn knows as well. Doesn't submit the bill at all. She takes as few cases as she can, doesn't submit the bill because she just doesn't want the hassle.
All right, thank you. Thank you, Judge Fisher.
I have a question. When the last study was done, I think, and we don't have the exact numbers, or don't quote me on these numbers, but let's say 30% of clients were indigent in the federal system and needed some form of representation, either through the FPD or through CJA attorneys. It appears now that those numbers are extremely different, that a vast portion of defendants in the federal system are needing appointed counsel or FPD representation or CDO representation. So you are all in private practice. All of you practice in federal court. I want to go one by one and ask each of you, Ms. Bednarski, what portion of your practice is in federal is retained versus appointed?
I believe 40% appointed, 60% retained in federal court.
Mm-hmm.
All my work in state court is retained, and all of our civil work, of course, is retained. I'm in a firm, so I'm not a sole practitioner.
Okay. And how big a firm are you in?
We have 4 partners and 3 associates.
All right. How
But
about
we
you?
also have a staff of paralegals.
Okay. How about you, Ms. Bonilla?
My state work, I would say it's half and half. My federal work, of the work that I do get, I would say 80% of the work that I do get in federal court would come from the CJA. So if I got 3 cases total that year, 2 and 1 private for that particular year.
And how many cases would you say you get federally a year?
Appointed cases? Well, we have a duty day system. So within the duty day system, if something comes in, then you're asked to get it, but not always something comes in on your duty day. So for example, I haven't received any appointed cases this year at all.
Okay. How about you, Ms. Curtis Palin?
I would say 95% of my federal cases are appointed cases. Same for my husband and law partner. Probably 95% of his federal cases. We are somewhat geographically distant from the federal courts, but a very large percent are CJA cases.
Your husband's is 95%?
As well.
Okay. Appointed?
Appointed, yes. State cases, probably half and half. Again, I have to make an exception for my husband because he is a contracted state public defender, so he is a state employee and has a large number of state public defender cases. But we also maintain our private practice and take retained state cases. But the vast majority of the federal cases are almost all appointed.
Ms. McNamara?
For us, I have a small firm. Three of us are partners, 1 associate, 1 contract attorney. I would say 75 to 80% is private retained. The remaining 25% is federal panel work. We do no state panel work.
Okay. And Mr. Solis?
Yes, I'm solo as well, and I would say my federal work is probably at any given time either 60% or 50% retained, and the balance is appointed. I don't do any state appointed work because I do have a lot of state work, but none of it's appointed, and the rest of it's retained. So,
All right. And so in each of everyone who answered the question and has some portion of state practice, it seems that the state clients seem better able to pay fees, that the federal clients are in some ways, there's a higher percentage that need appointed counsel. Does anybody have any sense of why that might be?
Oh, sure.
Okay.
The federal work is much more expensive. It's just the fees that I would charge in a state case for, just pick the crime. I mean, it's exponentially more in federal court. The cases are going to take longer. I mean, I tell clients, if you go into court, which won't happen, but if you go into court at the initial appearance and plead guilty, it's still going to take 4 months for you to get sentenced. The cases just take longer. And if you're talking about any kind of multi-defendant or large discovery or RICO case, forget it. Most of those people are priced out of hiring a private counsel. On a multi-defendant RICO case, maybe you'll get 1 or 2 private counsel, and usually those private counsel will drop out of the case and some panel attorney will have to pick it up at some point.
There's another big reason, and that's the forfeiture laws. Federal forfeiture laws make it impossible if you're charged with a drug offense to retain private counsel. The money's gone. And forfeiture is increasingly a priority of the Department of Justice in every case in which they can charge it. So in this district, we see a lot of white-collar cases that now carry very punitive forfeiture allegations. So in addition to complexity, length of time, there's forfeiture.
Anybody else have any thoughts?
There's another reason, which is that in state court, there's a natural point at which you can get out of the case if the client doesn't have any further money. So when you first get into the case, like prelim, there's an opportunity to review the discovery, do investigation, establish that relationship with the client, and possibly settle the case for a lot less than it would cost if you were retained to do a trial. And in federal court, we don't have that natural division. So when you're retained, you need to have enough money to stay in the case, because you can't count on a judge letting you out because a client ran out of money.
So would it be logical for this committee to assume that the majority or a great majority of defendants in the federal system are going to need some type of representation that does not come from the client? That's not going to be able to be paid by the client because of forfeiture, because of the cost, because of the sheer disability to pay those kinds of fees.
Well, I think also in the nature of the crimes in the state system and the federal system are very different. In the state system, you can have someone that will, maybe a random drug case, the police just sees that in a traffic stop. That's the whole investigation. In a federal drug case, you have months of wiretaps and lengthy investigation that you then need to, as the attorney, go do investigation, go wade through all the wiretaps and calls. It's just much more extensive because of the lead time in federal criminal investigations. There's so much more and so much more involved than in state cases where most of the crimes are fairly reactive.
Anybody else?
Your Honor, you also have a situation where even you do have a private client, the private client may not have the sufficient funds, be it to get forensic experts, such as fingerprint analysis or DNA, and then you go to the court and ask the court for money as if it would have been given to a CJA panel attorney. So I tend to agree with your statement that, yes, most of the clients, if not all of the federal clients, will need some sort of support financially.
So, last question. Is the concept of pro bono work realistic?
No, and I'll tell you why. Because in our district, we have multi-defendant gang RICO cases. There is no firm that can handle, for example, I could think of 3 cases off the top of my head, actually 2 that Judge Fisher presided over. They were years long. They were like serious hardcore gang cases with gigabytes of discovery and data. One of them I was involved in, the trial was 3 months long. I don't know any small firms or even any firms, big firms, that want to assign a person to say, you just disappear for 3 months for this gangbanger who killed another gangbanger. They're just not going to do it. You need dedicated people who are going to provide continuous representation for the entire case. So I can think of the 2 cases that I'm thinking of, Alfaro, Hawaiian Gardens. These are 4-year-long cases that I was able to represent the client wire to wire, meaning from the initial appearance to the conclusion of the case. And that's important because if you get fired, if there's a change of counsel for whatever reason, these cases have to be ridden out kind of like a bucking bronco because these cases and these clients are very difficult. But if you can do that, you're saving the system a lot of money because changes in counsel cost a lot of money, especially late in the process when someone late in the process, if they're not going to get severed, you're going to cause a delay in the trial, and all these people get moved, and then all those panel attorneys have to go and see their clients again and look at new discovery. The new discovery comes out. So pro bono may be great for your one-off mail fraud case, for the junior associate that wants to get some experience in trial. But for the majority of cases in our district, in the Central District of California, I don't see someone getting involved in gigabytes of discovery with tens of thousands of phone calls that you have to listen to and have some big firm get an associate that they're paying a couple of $100,000 to say, go off and provide competent representation in this case and don't worry about your billable hours.
Anybody else have any thoughts? Okay.
Ms. Palin, you alluded to something earlier in your testimony that I wanted to sort of follow up on, and I appreciate you being here because your situation in Wyoming is unique in terms of the panel size and geography and other aspects of what's happening there. And, you know, we've heard a lot of testimony from different places about the role of panel administrators or supervisory attorneys or case budgeting attorneys and things like that. But earlier in your testimony, you alluded to the, I guess, rugged individualism of the Western states and the idea of maintaining the local control. And, you know, I think rightfully so acknowledged that it probably wouldn't be the kind of thing that you could create this brand new position to take responsibility for the District of Wyoming and probably other districts across the country. And so I'm wondering if, given your experiences with judge involvement in or judicial involvement in vouchers and experts and the things that you've provided in your written submissions as well as your testimony, as well as what you've heard from other places regarding the impact of judicial involvement on those particular issues. If you would feel more comfortable with a judicial officer being the final decision maker on experts and vouchers, if the alternative was to have someone like a supervisory attorney who had criminal defense experience and background, was appointed or selected by the involvement of all the players in the system, including criminal defense panel lawyers, defenders, and the court systems, but that individual had to be in Colorado or somewhere else because, you know, just the logistics of the size of the panel and those kind of things meant that you couldn't have your own person, so to speak. Which would you choose?
That's a hard question because, of course, it would depend upon. The problem would be is that a person in Colorado that had our defender attitude or the defender spirit, it would depend on if they wanted to come to Wyoming and travel through the conditions we travel to and go all over our state and meet with our attorneys and develop that kind of personal relationship that honestly we do have with the courts. It's almost the devil you know is better than the devil you don't. And you know, so at least we do have that local, you know, but I have to appear in front of Judge Skavdal tomorrow. But on the other hand, sometimes it's my job to not make Judge Skavdal happy on some dates. It's my job to tell him that I disagree with what he said. So I guess, again, you look at balance, and I hate to see Wyoming lose its independence to Colorado, just because even though we're both Western states, we're vastly different than Colorado in the way our attorneys practice and in the troubles we face in our geography. So there is some amount of value, I can't deny, in having a judge who you're familiar with, who you practice with, to see that, as opposed to someone who's at the 10th Circuit Courthouse in Denver that you don't know on a personal level, or you wouldn't recognize on the street.
Just briefly, I know Judge Scavdall. He'll appreciate being referenced as the devil that you know. I'm enjoying that. But I want you to know that the back row has been listening intently. I just have a brief question or two. Ms. McNamara, your point is well taken about the quality of experts and ancillary services. A poorly written or unsupported report is worse than useless in my court, and I think I speak for a lot of other judges, and you know that it hurts your client in a court more so than not having one at all. And so that point is well taken. I do have a question. Even in the Northern District, in a well-functioning, a well-intentioned CJA panel selection committee, I think you serve on it, do you not?
I do, yes.
All right, and there are, and correct me if I'm wrong, there's 4 judges, 2 magistrates, 2 Article 3s.
Correct,
and
yes.
And then 2, a panel attorney and an FPD, is that correct?
On the selection committee, it's expanded. So it's the federal defender, myself, we're permanent members of the administration committee, and then there are 4 other CJA attorneys who represent sort of different geographical venues in the district.
All right, well then you are perfect. My question was going to be...
That's my opinion, yes. Thank you very much. Yes.
My question was going to be whether, even a panel like that, whether you felt it was skewed towards judges, or whether there was an intimidation factor, and I trust that your answer is no. Then
no, although our judges are plenty intimidating. I do want to say that they're. I appreciate the question, because I think that is a concern that we have.
Well, it is in some districts. It certainly is, and I think we need to be cognizant.
And I've heard this many times. I've attended now, I think, 6 national CJA conferences, and people tell me that all the time. They say, in my district, I couldn't possibly say X, Y, and Z to our judge. He would get offended, or she would have me off the panel. And I come back to the sort of note I've been harping on, and that is, when we as a community of CJA lawyers see that we're there in force, six of us, that we're in every committee that makes decisions, that the judges consult us first when they have an issue with a lawyer, we feel like we can actually say truth to power. And I really think that's the solution. It's just, a structure that encourages participation at every level. If it were just once a year that we were invited in, I think we would have a real problem. And the other thing I can tell you is, in instances where we have said to the court, we disagree with you on your view of a particular attorney, we see that they pay attention to that. They may not always agree, but 9 times out of 10 they agree. And it goes back to what Judge Gonzalez-Rogers says. The ultimate thing we feel in our district is that the court respects us and understands that we provide something valuable. One other thing before I leave it, if I may. The people on our panel who provide services are dedicated people, and there's a sense of vocation. There are people who go to the jail after hours to make sure their clients are released. They don't charge the program for that. They just want to do it because they want to make sure a human being gets out of jail. There are people who, after a case is over, find jobs for their clients. They don't do that for pay, they do it for a sense of vocation. There are people who make sure their clients get their driver's licenses back. We provide all manner of what might be considered social services because we care. We really care about the work. All of us here on this panel don't need the work. Many of us are former public defenders. We want to do this work. We feel strongly about it. The court here recognizes the value of that.
Very well, thank you.
In light of the time, I'll defer to the professor.
Professor, briefly.
We're past, all right, then 2 questions. For those of you who have mentioned arbitrary voucher cuts, not voucher cuts, but arbitrary voucher cuts, what's the extent of the problem? Are we talking about a few judges in your district, or are we talking about a pattern in practice across the entire district?
Our concern is really it's a growing trend, because what we've seen in the last year is more and more cases being referred to the presiding judge for the reasonableness review. And out of that has come these two extreme cases. And we see it reverting to a system that used to be many years ago, where one district court judge would just slash a bill 50%, or another district court judge would just slash a bill 30%. So the real concern we have is that increasing more and more. We hope these two things never get repeated, but it does seem like more and more Judge Smith is referring things for reasonableness reviews to the district courts. So we expect to see more and more sort of half of these hours are gone and half of these are gone.
And they're arbitrary because there's no meaningful explanation. I think you heard on the last panel, the judge said, well, it's just a gut feeling. So if you have a judge who cuts your bill by a certain amount of money and said, well, it was just a gut feeling. I mean, how is a panel attorney supposed to take that? What was it about my bill? What line item did you have a problem with? Then there's no review, because in our district, the review process was go to the circuit judge, and he will determine whether the district judge abused his discretion. Oh, no, he didn't, don't worry. And that's it. It's over. There's no other meaningful review, and there's no explanation, and you cannot demand like an accounting or saying, what was it about my bill? What line item? What did I do that was unreasonable? Because I don't know many or any people in our panel that just say, well, I'd love to spend hours on end with this guy who I've never met in the Metropolitan Detention Center because I want to generate up a big bill at $129 an hour.
Okay. One last question. I am struck by the disconnect between many of you saying that the hourly rate needs to go up or you're going to lose people off your panel, and at the same time saying that there is self-cutting going on across your panel, and yet people are staying on the panel. So is this a situation where you have people on the panel who shouldn't be on the panel, and or is this a situation in which there's a great deal of pro bono service going on by those who are on the panel?
Well, I'll just say from the Central District, we have a couple of people who are excellent attorneys that just came out of the Federal Public Defender's Office that got out and thought they would take a certain number of panel cases, and then they had so many problems with their bills, they don't want a bill, and they want to get off the panel.
But they're not.
They've stayed on, but I will tell you, they give away their duty days, they're declining, they're taking fewer cases, they're effectively getting off the panel, because even though they were recently on the panel, they're winnowing away their panel cases to the point where they're very few. They want to maintain a connection with the panel, because there's a lot of camaraderie, and they want to do something for the court, but they're taking fewer and fewer cases and giving away their duty days.
Okay. The rest of you?
I believe there is cutting, self-cutting, and it is a form of pro bono. And it is done because we're actually encouraged to really look at our bill and treat it as a private client. And, you should cut your bill a little bit. So you're already with that mindset. And I discourage that.
Who's doing that encouraging?
Oh, it's right in the plan, in our guidelines.
It's part of the plan?
It's in our guidelines, yes, in our
Okay.
guidelines, yes. Yes. And I disagree with that. I think we should bill for every minute.
Okay. Anyone? I know we're over time. Thank you very much.
Thank you very much, and please remember that if you think of something else or anybody that you talk to has anything else that they'd like to present to the committee, that we continue to take written testimony by submitting it to our website, and we'll also take testimony submitted confidentially. So, thank you.